And it is your claim that you and your husband went out of town, and it is your claim that the defendant stole a car of yours and had an accident with that car, and you want her to be responsible for it.
From the moment the courtroom door closed, the air grew heavy with conflict, opposing narratives, and emotions pushed to their limits. This wasn't just a civil dispute over vehicle damage. It was a psychological drama where the truth was stretched, people confronted responsibility, and Judge Judy, with her sharp experience and instinct for human behavior, peeled back every layer with chilling precision. The hearing began like hundreds of other cases. A plaintiff who believed they'd been taken advantage of, a defendant insisting they'd done nothing wrong, and a car at the center of the dispute. But as the testimony unfolded, every word from O'Brien, the plaintiff, revealed signs of defensiveness, hesitation, and the fear of being exposed. Meanwhile, MacKenzie, the defendant, showed the calm of someone who believed they were caught in an unnecessary problem. What made this case a textbook lesson in psychology and law was Judy's approach. Not emotional, not prematurely judgmental, but grounded in behavioral logic, the trademark that defines her.
The total miles that we put on the car was 4.3 miles. We got home, we barely made it in the driveway, and it stalled out again. My son came out, we had to push the PT Cruiser up about 15 feet uphill, and all the oil just spilled all out.
When O'Brien claimed the car was severely damaged, undrivable, leaking oil everywhere, and that the issue was a direct result of MacKenzie's actions, the story initially sounded reasonable. Anyone listening only to O'Brien could easily picture a wrecked car, barely clinging to life on the side of the road, as proof of the defendant's irresponsibility. But in civil cases, especially with Judy, the issue isn't the size of the story, but the way it's told. From the very first minutes, Judy watched O'Brien's posture, eye contact, and vocal emphasis. Every time the plaintiff avoided eye contact or shifted her stance when discussing the damage, Judy mentally logged them as behavioral red flags. She didn't rush to accuse, but Judy knew this was a story that needed to be dissected through targeted questions.
She used the car.
Yes.
Returned the car. Car is now back, and you take the PT Cruiser and travel with it for 4 miles.
The moment Judy referenced the 4.3 miles, the distance O'Brien and her husband drove this supposedly undrivable car, the entire hearing shifted. Judy's question sounded gentle but razor-sharp, slicing into the weakest part of the testimony. If the car couldn't be driven, as you claim, why did you drive it to work and to the supermarket? It wasn't a question seeking an answer, it was a test of the witness's reaction to logic.
Listen, Miss O'Brien, I'm not buying your story, my dear. I started out with you with difficulty because what you wrote here was you couldn't find her for a year.
And O'Brien's reaction was exactly what Judy focused on. Her eyes darted, her voice softened, and her posture shrank, classic signs of someone cornered by their own inconsistencies. From a behavioral psychology standpoint, this was the reaction of someone trying to defend an inaccurate story. When the truth isn't on your side, your body betrays you before your words do. Judy didn't stop. She pushed further by using a principle every driver understands.
You come home, you drive the car, don't see anything wrong with it. There's no evidence that it was in a crash. There's no evidence that it was vandalized, damaged in any way. And you drive it first to a job. You do the job. Car isn't exploding. Car isn't sizzling. Car isn't smoking. You and your husband don't quickly take it to a mechanic to see what's wrong with it because there was nothing wrong with it.
Judy didn't need to be a mechanic to know that. She only needed life experience and courtroom experience. Here, that experience became a sharp legal tool. When Judy said, "That couldn't have happened," she wasn't just rejecting the statement, she was attacking the foundation of witness credibility, the most crucial factor in small claims court. From that moment on, everything O'Brien said carried a shadow of doubt.
And as soon as we got halfway there, it was running really, really rough. When I got to the school, I texted Bonnie and said the car was running really, really rough. Didn't hear anything. When we left the school, we drove 2 more miles to the grocery store, and the car stalled out right there.
O'Brien tried to recover, claiming the oil leak was worse when she got the car back. But Judy instantly recognized this as escalation, a classic sign of someone adjusting the story to fit newly exposed facts. When a witness changes their story based on questioning instead of truth, their credibility collapses. And Judy, who has handled thousands of similar cases, recognized it instantly. Her gaze sharpened, her voice flattened the unmistakable signs that she had smelled dishonesty. Judy continued questioning why O'Brien didn't get the car repaired immediately if it was as dangerous as she claimed. This was a legal question asked in a psychological way. People avoid risk. No one voluntarily drives a ticking time bomb through the city. When O'Brien couldn't answer, her silence spoke louder than any explanation. Judy gently but firmly concluded that the car was not severely damaged when returned. The major damage occurred because O'Brien continued driving it without coolant. Responsibility then shifted completely back onto the plaintiff. This was the turning point. Legally, Judge Judy was applying the principle that if the defendant caused only minor initial damage, but the plaintiff worsens it through continued misuse, the responsibility shifts to the plaintiff. This is the principle of mitigation of damages, the duty to minimize harm, a basic concept many people don't understand. Not only did O'Brien fail to minimize the damage, she made it worse, then tried to blame someone else. A case that could have been reasonable turned into an attempt to exaggerate for higher compensation.
Your Honor, I have the fireman that owned the store that stated she was living in the pizza place. So did a former employer.
Just a second. Then serve her at the pizza place.
Cornered, O'Brien suddenly introduced an unrelated story. She knew MacKenzie lived at a pizza shop. This is a common tactic among weak plaintiffs: distract and attack the defendant's reputation or personal life. But to Judy, this was the mark of desperation. And that's when she responded with one of her signature lines. "I don't believe you. That's the problem."
Just serve her in the pizza place. I don't believe you. That's the problem. I don't believe you. What you wrote here was inaccurate because she didn't steal the car.
I don't believe you. That sentence didn't just close the chapter of testimony, it was the final judgment on O'Brien's credibility. In Judy's courtroom, once you lose trust, you lose the case.
Goodbye, Miss O'Brien.
She didn't need to shout or complicate things. One quiet, razor-sharp line, "Goodbye, Miss O'Brien." That was the dismissal, a cold, perfectly reasonable ending. From a behavioral standpoint, this case shows something clear. People don't always lose because they're 100% wrong. Many lose because of the way they tell their story. The truth doesn't need exaggeration to be convincing. A lie, however, collapses with just one well-placed question. Had O'Brien focused on the minor damages and simple negligence, she might have won or at least received partial compensation. But she chose to weave a tragedy, turning a small error into a disaster, a technical issue into wrongdoing. And that's exactly what made Judy see the truth. The most striking part was how Judy used behavioral logic to illuminate the truth. She didn't scold or pressure. She asked open-ended questions and watched bodily reactions, something liars cannot control. Each time O'Brien changed her tone, avoided eye contact, or swallowed nervously, Judy noted it. When witnesses reconstruct a story to benefit themselves, their body language rarely aligns with their words. This happened repeatedly with O'Brien. Meanwhile, MacKenzie remained calm, didn't overreact, and didn't retaliate. Those are the signs of someone with nothing to hide. And Judy saw the contrast clearly from the start. From a societal perspective, this case isn't just about a car or two people in a courtroom. It reveals a bigger issue. In civil disputes, many people exaggerate the truth because they believe it will help them win. But the law doesn't operate on emotion. The legal system doesn't reward great storytellers, it rewards honesty and consistency. When people bend the truth, they don't just destroy their own credibility, they erode trust in the legal system itself. In my opinion, O'Brien isn't a bad person. She just let her emotions take over, allowing the desire for greater compensation to overshadow honesty. But that's the bigger lesson. In the courtroom, emotion cannot replace truth. When you start with a lie, you've almost signed your own dismissal order. Through Judy's handling, this case became a real-world lesson in logic, behavior, and the consequences of exaggerating the truth. From start to finish, Judy did nothing but ask the right questions in the right places, and those questions exposed everything. This wasn't just a hearing, it was a lesson on honesty. And if anything remains with the audience, it's the message that in law as in life, the truth needs no embellishment. It stands on its own. A lie, no matter how beautifully dressed, reveals itself under the light of reason. This case is the perfect proof of that.